We'll wait for a couple of minutes for people to start joining in. Good evening, Mr. Bansal. I can see you, but if you can just speak a couple of lines to test the audio.
Very good evening, Deepika ma'am. How are you?
Good to see you. We'll just wait for a couple of minutes before we begin.
Yes, ma'am.
All right. I think we are good to go. We have a decent participation. Good evening, everyone. Thank you so much for taking the time out on a Monday evening to join us. As I was mentioning, this is perhaps the first time in 2 years that we can't really assume you all are joining us from your homes. So wherever you're joining us from, court, office, college, I hope the next 1.5 hours is worth your while. I'm Deepika Kinhal. I lead the Judicial Reforms Vertical at Vidhi Center for Legal Policy. We call ourselves Jaldi Mission, which is Justice, Access and Lowering Delays in India mission. We have over the last few years, as a bunch of lawyers, tried to understand how the justice delivery systems in India work. We do this through doctrinal research, data-based research, as well as speaking to people within the system. In the last few years, we have published numerous reports covering issues such as the infrastructure, judicial administration, use of technology within the judiciary, all of which highlight the problems that are there with the processes within the justice delivery system. As we know, the two key words that are associated with the judiciary today, unfortunately, is delay and pendency. But what is happening behind the wheel, which is leading to this problem, is what we are here to understand. While we have done in-depth research with respect to processes, what we realized was that ultimately it is the people who have to bear the brunt of those archaic processes and even the new rules, which may not really cater to the requirement. Towards this, last year, we tried to identify different stakeholders within the system beyond the judges. Usually the judiciary is sort of correlated with the judges themselves, while in fact, there is an army of people who support a judge to enable effective justice delivery. One such key actor we thought we will focus on is public prosecutor. This was also driven by certain cases that came up last year where the focus was on the role of public prosecutor. When we started looking at what their roles are, responsibilities are, and where the issues lie, we were quite surprised with the lack of scholarly research on this topic. So to fill this gap, Jaldi took this project up last year, and today we are here to release the report officially. We have the authors of the report here with us, Chitrakshi and Aditya Ranjan, who will be making a brief presentation on the findings of the report. Followed by this, we will have a ceremonial launch of the report, if you will, by our stellar panelists. We are honored to have Justice Cunha joining us today. He, of course, needs no introduction. He is known for his steadfast judgments, especially in cases involving politically charged criminal cases. To give a brief introduction to Justice Cunha, he joined the judiciary in 2002 as a district judge after practicing for more than 15 years. He served as the secretary to the Chief Justice, Registrar Vigilance, and Registrar General at the High Court of Karnataka. He was then appointed as a High Court judge in 2016 and retired in April 2021. He has delivered several landmark judgments and is especially known for his crisp judgments that I particularly enjoy reading, which always have really keen appreciation of evidence. Justice Cunha has kindly agreed to deliver keynote address during this session, and he will also join us as one of the panelists later on. We then have Mr. Ranjit Thomas. He is currently an assistant professor of law and executive director of Center for Criminal Law Studies at NLUJ. His areas of expertise are philosophy of criminal law, administration of criminal justice system, and sentencing. He has to his credit several publications and is also associated with judicial academies, Intelligence Bureau, and Bureau of Police Research and Development. So thank you so much for joining us today and also for your support during the course of our research. Mr. Thomas, he peer reviewed our report and we are grateful for that. Last but not the least, we have with us a representative of the office that we are going to be discussing in detail today, Mr. Rajat Bansal. He is currently serving as an assistant public prosecutor in Saket Court in Delhi. He obtained his law degree from National Law School, Patiala, and now has a decade-long experience in the field of criminal law, both as a lawyer and now as an assistant public prosecutor. With that introduction to the panelists, I will start with the first bit of our session today, which is report presentation by Chitrakshi and Aditya. Over to you.
Thank you, Deepika. I'll just share the screen.
Should I start?
Yeah.
Sure. So good evening, everybody. Thank you for joining in. The report that we are presenting today is titled The Quest for Prosecutorial Independence, where we are studying the Office of Prosecution in India. Let's go to the next slide. Yeah. So we realized when we began this study that this is a fairly understudied office in the criminal justice system and never really the most glamorous actor in the criminal justice system, which is why it has, escaped attention. But there are other reasons that make this office more difficult to study. So criminal procedure is a concurrent subject, which implies that the center and the states can legislate on it. As a consequence of this, while there is a clear scheme laid out in the code with regard to the appointments and functioning of prosecutors, we'll find variations in rules and practices at the state level from the central scheme. So there is no one uniform way in which this office functions across India. There will be state level variances in their appointments and their functioning, which impact their behavior in the courtroom. The other thing that makes it more complicated is there are different classes of prosecutors. So there is a class of prosecutor which is assigned to work with the magistracy, with the sessions court, with the high courts, and their appointments and functioning differ depending on their selection procedures. The objective of this report is to look at the scheme provided in the criminal procedure code and assess that scheme vis-a-vis the independence that the office enjoys. So we realize that there are many judgments which extol the values of independent functioning of the Office of Prosecution, but seldom do they pay attention to the external factors. For example, the structural rules under which this office functions, the way they are appointed as public prosecutors, which have an impact on their functioning inside the courtroom. We also evaluate the code in terms of the discretion that they assign this Office of Prosecution. And we find that it even statutorily, not much discretion has been envisaged for the Office of Prosecution, to function in an independent, effective manner. Let's go. Yeah. So with regard to the scheme of Section 24, so now Section 24 is sort of a code unto itself when it comes to public prosecutors. we look at certain factors which impact the selection of public prosecutors. The first being adequacy of checks in the appointment process. Now, the only check which is envisaged in the code is the involvement of the judiciary, where consultation with the district judge in forms of preparing the panel through which these prosecutors are selected is necessary. We also look at this other class of prosecutors called special public prosecutors. Now, there are two kinds of SPPs. One which are assigned in special legislation, say for example the Prevention of Atrocity Act, which envisages special courts and special public prosecutors to work in those courts. What we are looking at are SPPs appointed under 24 subclause 8 of the Criminal Procedure Code, which are prosecutors who are appointed in certain cases or a class of cases. We look at the challenge in establishing a prosecutorial cadre. Now, I'll go to these issues individually. The power to appoint prosecuting officers vests with the central and the state governments. There is only one check contemplated in the code, where the judiciary's consultation is deemed necessary in this appointment process. So the district judge has to prepare a panel name through which the selection will be made. Now, what we have found is a lot of states have circumvented this requirement of involvement of the judiciary by amending the provision of Section 24. There has been a lot of litigation in this regard as well in certain states, for example, in Uttar Pradesh. Let's go on. Yeah. What is also more disturbing is the rampant use of appointments under Section 24, subclause 8, which is the appointment to the Office of Special Public Prosecutors. Given that the law is fairly, it doesn't say much on the criteria and the circumstances in which such appointments should be made, what we found was that cases in which there is greater media scrutiny are more vulnerable to have special public prosecutors than regular prosecutors. And we saw this especially with regard to the Delhi riots cases, and given that the structure, the legislative distribution of power in Delhi is also very complicated, we saw a tussle between the office of the state government and the governor fighting over the appointments of public prosecutors. So that makes it very clear that these appointments are executively and politically motivated, and mostly are attracted in cases which are high profile cases. Now, there are certain drawbacks to such appointments under Section 24 clause 8. These appointments are often not accompanied with written reasons for which a special which justify such appointments in special circumstances. There is a very vague criteria of an advocate who's had 10 years of practice to be appointed as an SPP, implying that a more competent lawyer is being hired as a SPP. But what the practice of this provision reveals that it's mostly just attracted in high profile cases, not really the complexity of the case. The other challenge with such rampant appointments is that it ousts the jurisdiction of the regular prosecutors, because such challenging high profile cases are also important for regular prosecutors to learn from. So if they keep appointing SPPs in these high profile cases, you're also depriving the regular prosecutors of the opportunity to, for career growth by experiencing and prosecuting in such cases. Let's move on. So the code was really clear in its aim to establish a prosecutorial cadre, where they wanted that the entry level to the highest court, there should be the people who are selected through public exams at the level of assistant prosecutor should move on to work with the sessions courts, etc. What we have seen is that the tenured and the contractual class of prosecutors has resisted it, and the state governments have also amended this provision and sort of diluted the rights of assistant public prosecutors to have a career progression in the criminal justice system. With that, I think Aditya can take us through the rest of the discussion.
So in the second part of our study, we worked on the functions that the prosecutor performs in a criminal trial, and we looked into three key functions in a criminal trial: first, investigative stage; second, charging stage; and third, withdrawal of the cases from prosecution under Section 321 of the code. Firstly, in the investigation stage, we studied and we found that there is no statutory power or discretion that a prosecution currently plays at the investigation stage. And as a result of this, the decision on whether to prosecute a case or not rests solely with the police and is subject to the approval of the court. While some states have introduced mechanisms for the prosecutors to scrutinize final report and then assist the police in the investigative functions, it is not uniform across the state. Secondly, the charging stage is another key stage at the criminal trial. In this stage, the prosecuting officer is expected to assist the court in framing of accurate charges. However, in practice, we found that the prosecutor often urges the court to frame the exact same charges that are recommended by the court in the final report or the charge sheet, as the case may be. The limited role of the prosecuting officer at these pre-trial stage results in their limited role, as well as their opinions not being taken at these key stages of the trial. We recommended this report for a more involved procuracy, and also what we recommend an advisory role for the prosecutor at these pre-trial stages. Thirdly, we also analyzed one key role of the prosecution that is under section 321 of the code, which provides for withdrawal of cases from the prosecution. Now, this particular section empowers the prosecutor to withdraw cases from prosecution in furtherance of object of law and to promote public justice. Under this section, the prosecuting officer is expected to apply her independent mind and decide upon whether to withdraw a case or not. And this responsibility cannot be betrayed in favor of anyone superior to her at the administrative side. However, we have seen that there has been increasing executive interference in this function. While the state government performs the role of recommending withdrawal of cases and suggesting withdrawal of cases where it thinks that such action will promote administration of justice, the state government and executive has often overstepped this mandate. Many states have enacted rules which mandate sanction of the executive officer under the legal manual or related document for the withdrawal of prosecution, for the application of withdrawal of prosecution to be put before the court. In addition to this, the general lack of independence that a prosecuting officer suffers from makes it difficult for the prosecutor to apply her independent mind or to protest against any directives given by the state government to withdraw cases. As a result of this, we found two key trends emerging with respect to withdrawal of cases from prosecution. First is that this provision is seldom used in many states. The provision that was initially intended to weed out weaker cases and to promote interest of justice is not, the prosecuting officers are not using this provision at all in certain cases and enough in many cases. In 19 out of 36 states and union territories, we found that in the 5-year period between 2015 and 2019, there were less than 35 cases withdrawn under IPC. And in all these cases, the number of cases filed were in thousands and lakhs. The second and more concerning trend that we analyzed is the increased use of this provision for political purposes. We saw that many political parties have been using and have been citing this provision of withdrawal of cases in their manifestos, election speech, and in the electoral promises that they make before elections. That's why we went and analyzed a number of withdrawal of cases across the change of political party in power in the period between 2015 and 2019. And the result we found were something that was really concerning. As presented in this graph, we found that there were 14 cases of change in political party in power or political coalition in power between 2015 and 2019. And among these 14 instances, 10, which is 70% of cases, resulted in a spike in the withdrawal of cases from prosecution. We also found that in 7 of these cases, the number of cases withdrawn in the year of change of government in power itself was more than 45% of the total number of cases withdrawn across the 5 years. So there is a clear link between the application of withdrawal of prosecution and withdrawal of prosecution by the public prosecutors under section 321, and the change in political party in power and the electoral politics. Based on these observations, we make 5 key recommendations under the report. First, we recommend establishing of objective standard and comprehensive process for appointing of prosecutors, which will take into consideration their fitness and other factors related to that, for them to perform the function as prosecutor optimally. Secondly, we recommend guiding executive discretion to appoint SPPs through rules and regulations. Right now, as Chitrakshi mentioned, the provision for appointment of SPP does not provide much guidance for the executive of which cases and which situations mandate or warrant a appointment of SPP into a case. Because it results in ousting of regular prosecution, there has to be some guiding regulations for these appointments. Thirdly, we recommend expanding the role of prosecutor at the pre-trial stage, particularly at filing of final report and charge sheet, and also at the framing of charges. Fourthly, we recommend eliminating executive interference at the withdrawal of cases from prosecution under section 321. And lastly, because in the report, we emphasized on increasing the power and autonomy of the prosecutor, we recommend creating a robust system for prosecutorial accountability. And we have also referenced it with the Office of Prosecution at other Commonwealth nations. And we recommend a robust system of accountability either towards legislature or towards an independent body, and through which the prosecutorial agency can be held accountable and the optimal functioning can be obtained. Thank you.
Thank you, Aditya and Chitrakshi. Some very hard-hitting findings over there, especially with respect to the appointment of special public prosecutors and the link between withdrawal of cases and election years, especially if the political parties are putting that up as part of their manifesto promises. There is definitely a huge concern regarding independence of the role of public prosecution and how that is playing out on ground. So congratulations to Chitrakshi, Aditya, and Jigar Parmar, who is the third author who unfortunately couldn't join us today. But I'm hoping that what you've done here is going to be a conversation starter at the very least to make the Office of Public Prosecution function better. We will now proceed to, as I mentioned, ceremonially launch the report, release the report. So if I may request the panelists and authors, if they already have a hard copy of the report, to just hold it up for a quick snap.
Yay.
Okay. Kanav, did you get that?
It would be great if everyone will held it up once more, please. Great, thank you.
Thank you. Thank you so much. Now we proceed towards Justice Cunha, who has kindly agreed to give a keynote address at the release of this report. Justice Cunha, I would like to begin by thanking you for taking the time out on behalf of us here and the entire Vidhi community. Over to you, Justice Cunha.
Yes. Respected panelists, Professor Ranjit Thomas, Assistant Public Prosecutor, Shri Rajat Bansal, Shri Aditya Ranjan, Research Fellow, Chitrakshi Jain, Legal Researcher, Madam Deepika Kinhal, Lead Judicial Reforms, Vidhi, all other team members of Vidhi Center for Legal Studies, ladies and gentlemen. It is really a happy occasion for me to participate in the grand release of a research report on a subject which is of utmost importance in criminal law relating to the functioning and independence of public prosecutors. As already told, this is a subject less studied and less discussed in public platforms, and that, in my opinion, lends further importance to the report that is being launched today. Therefore, at the outset, I congratulate all those who are instrumental for the launch of this report, quest for prosecutorial independence and express my sincere appreciation and commendation to the authors, Ms. Chitrakshi Jain, Shri Aditya Ranjan, and Shri Jigar Parmar for the painstaking job done by you in bringing out this report. I'm sure, like other research works published by Vidhi on diverse subjects, this report will also generate genuine public discourse and pave way for the reforms recommended by you in the matter of appointment and functioning of the public prosecutors. I think with this, let me straight away get into the subject. I think the term public prosecutor is defined in section 2U of the code, meaning any person appointed under section 24 and includes any person acting under the directions of a public prosecutor. Section 24 deals with the power of appointment, eligibility for appointment, and the purpose of the appointment, that is, for conducting prosecution, appeal, or other proceedings on behalf of the center or the state government. Thus, in view of this provision, one thing is clear, that the power of appointment is vested with the government. I think by now, law is well settled that the power conferred on the government is not absolute. It is subject to consultation with the respective High Court or the session judge, as the case may be. But in practice, what we see is that on every change of government, there is change of SPPs or public prosecutors or the government advocates, implying thereby that only advocates with party affiliation get into the office of a public prosecutor, irrespective of their caliber, capacity, efficiency to assist the court. If we really understand the nature of duties and functions discharged by public prosecutor, I share the view that this sort of appointment is counterproductive and defeats the very purpose of the creation of the office of the public prosecutor and greatly impinges upon the independence of the office of the public prosecutor. Of course, regarding the power of the government to make the appointment is concerned, law seems to be well settled in state of UP versus Johari Mal, wherein the Honorable Supreme Court has said that the crucial performance of advocates should not be the sole criteria for their reappointment, and that the state government should be free to repose trust and confidence in the persons whom they choose to appoint. But the manner in which this power is to be exercised, that finds place in para 40 of the decision, which I find it necessary and worth to quote. And I quote, "Only when good and competent counsel are appointed by the state, the public interest would be safeguarded. The state, while appointing the public prosecutors, must bear in mind that for the purpose of upholding the rule of law, good administration of justice is imperative, which in turn would have a direct impact on sustenance of democracy. No appointment of public prosecutors or district council should thus be made either for pursuing political purpose or for giving some undue advantage to a section of the people. Retention of its counsel by the state must be weighed on the scale of public interest. The state should replace an efficient, honest, and competent lawyer inter alia when it is in a position to appoint a more competent lawyer. It is not when with the change of the government and mass you change that. If there is a competent lawyer only, you should replace him, substitute him. In such an event, even a good performance by a lawyer may not be of much importance. So that is what has been laid down by the Honorable Supreme Court, even regarding the power of the exercise of the power by the government in appointing the public prosecutor. See how this procedure of appointing the party sympathizers could affect the administration of justice, I think could be well illustrated in the case of Kumari Jayalalitha. I think almost every one of you may be knowing there was a case when by the time the accused number one assumed the office of the chief minister, the evidence was already over. 313 statement was over. And at that time, she assumed the office, and on the next day, there was a change of the public prosecutor. And what the public prosecutor does is, after this public prosecutor assumes the charge, an application is filed by the accused to recall as many as 115 witnesses. And the public prosecutor does not oppose. And these 115 witnesses, they totally resile from the previous statement, and it does not even cross-examine them, does not even treat them as hostile, does not even proceed for taking action for perjury. And it is in this context, you may be knowing it, the matter reaches the Honorable Supreme Court, and the Honorable Supreme Court has come down heavily regarding the way, and even the matter went on to transfer the entire case from one state to another. Even after the change of the this one, see, this is a case where I could share with you this what is the relevance or the importance of a public prosecutor, what he can do and what he cannot do. See, after the appointment of a new public prosecutor, see, he recalled by the permission of the court all these somehow nearly 76 witnesses. Out of them, he cross-examined 26 witnesses. And the entire case of the prosecution was substantiated by recalling this evidence. See, that is the power, and that is the assistance, and that is the caliber of a public prosecutor in a criminal case. And therefore, the public prosecutor is put in charge of the efficient public prosecutor is put in charge of a criminal case. So therefore, this is an instance where this appointment leads to it. We can say it's nothing but throttling of justice, and not the assisting the court to reach a fair decision. I think with this, on this first point, now let me pass on to the next question, as to what is the role of the public prosecutor in the administration of justice. I think on this point, we have an authoritative pronouncement of the Honorable Supreme Court in the case of Rekha Murarka versus State of West Bengal, 2020, Part 2, SEC, page 474, wherein the Honorable Supreme Court has made very crucial observations, and it is worth to extract it or to quote here in Para 7. In our criminal justice system, the public prosecutor occupies a position of great importance. Given that crimes are treated as a wrong against the society as a whole, his role in the administration of justice is crucial, as he is not just a representative of the aggrieved person, but that of the state at large. Though he is appointed by the government, he is not a servant of the government or the investigating agency. He is an officer of the court, and his primary duty is to assist the court in arriving at the truth by putting forth all the relevant material on behalf of the prosecution. The role is defined here. I'll come to it in detail. The space carved out for the public prosecutor is clearly that of an independent officer who secures the cause of justice and fair play in a criminal trial. This sums up all the qualities or the functions of a public prosecutor. I think these observations, I would say, they throw light on very many questions surrounding the functioning of the public prosecutor and their independence. If we understand these observations right, and also analyze the scheme of the code wherein the role and functions of the public prosecutor or assistant public prosecutors are defined, it is clear that the public prosecutor cannot be a part of the investigation team. And that is what has been laid down there. He cannot even supervise the investigation. He is appointed only to conduct the prosecution. He is appointed by the government, but he is not the servant of the government. His duty is to assist the court. That is his primary duty, to assist the court in arriving at the truth and not to assist the IO. The space carved out for him is that of an independent officer. But unfortunately, in reality, what we see is that public prosecutors work in tandem with the police and the executive thereby compromising the very independence of their position. I think here I'm differing from the view taken by the authors in their report, and I'll try to justify it. See, in Karnataka, I'm told that the Director of Prosecution acts in close cooperation and coordination with the DGP in all matters connected with the conduct of the prosecution in the magistrate and sessions court. Senior assistant public prosecutors are posted in the SP's office. This, in my view, is opposed to the basic tenets of our criminal justice and contrary to the scheme outlined in the Code of Criminal Procedure. Under the code, the role of investigating officer, public prosecutor, and the court are clearly demarcated. Investigation is the exclusive prerogative of the police. Even the court cannot interfere in the investigation. No magistrate can direct the IO to file the charge sheet. After the conclusion of the investigation, that is after the collection of the evidence, it is the IO who has to form his opinion and submit his report. That is called as a final report. It is the opinion of the IO based on the evidence or the material collected by him. Somebody else, the public prosecutor, cannot substitute his opinion. So that is not envisaged in the code. See, there was a practice in most of the states for the public prosecutor to vet the final reports or the charge sheet. But after the decision in R. Sarala versus T.S. Velu, AR 2000 SC 1731, this practice is mostly discontinued. Supreme Court has clearly held that collaboration between the IO and the PP for filing of the report is against the scheme of the code. And it is rightly so, because if public prosecutor, who is considered, as I already pointed out, as the officer of the court, and whose primary duty is to assist the court in arriving at the truth, he cannot be seen involved in preparing the report which he himself has to present to the court. That would give rise to conflict of interest and scope for manipulation of the evidence. Of course, I have not dilated on this point. I think if at all there should be any counter argument, it is on this count. Of course, in this short duration, I cannot go in detail on this. So there is another reason why PP should keep himself away from investigation. That, as all of you may be knowing, we have been following adversarial system of trial, where accused is pitted against the prosecution. The judge acts only as an umpire. The burden of establishing the guilt of the accused is primarily on the prosecution. And this duty is entrusted to the public prosecutor. Section 225 of the code mandates that in every trial before the court of session, the prosecution shall be conducted by the public prosecutor. That's the mandate. He shall conduct the prosecution, not investigation. Section 25 lays down that prosecution in the court of magistrate shall be conducted by APP. Any private person or the victim cannot sneak into the prosecution, even if PP or the APP is found inexperienced, seen to have been abdicating their responsibility, or palpably acting under pressure. The victim or the complainant cannot take the reins of the prosecution. He can only assist. I think that law is very much clear under section 301 of the CRPC, by getting the permission of the court. The only place where the public prosecutor or the assistant public prosecutor could be substituted is under 302. That is only in the court of the magistrate, not in the court of sessions. Under 302, I think the APP could be replaced, and that trial could be conducted by a party, permitted by the court. So therefore, the scheme of the code makes it very clear that a public prosecutor cannot be a part of the investigation. His role is to conduct the trial and to assist the court. And therefore, I think from which it follows, strictly speaking, he should be appointed by the court, because we call him as an officer of the court. Just like any other employee or officer of the court, if you see the history of the various enactments, I think that is what you yourself have collected, right from 1888, the power of appointment was retained with the government, maybe because initially the prosecution was conducted by the police officers. and therefore they were brought under the department, under the Home Department. But now, after the 1973 code, there is a clear demarcation of the role of the investigation and the prosecution, as well as the court. So the judicial precedents have also defined the essential functions of the public prosecutor and have clearly laid down as an officer of the court. Therefore, being a functionary of the court, it would be proper that even the power of appointment and administrative control over the public prosecutors should be taken by the judiciary so as to effectuate the purpose and object of the office of the public prosecutor, and also to ensure independence and accountability, and also to restore the dignity of the office of the public prosecutor. I think I've covered, I think within how much time is left? I think, of course, there are some other issues that is regarding the power of withdrawal. I think regarding
please
the power
Justice Cunha, if you can complete your address.
Yes, now there is
We
that's
have a
nothing
few
because
minutes.
regarding these powers, I don't think, because the extent of this power is specified in section 321, and the judicial precedents have already delineated to under what circumstances, and even the guidelines have been laid down in Rajendra Kumar Jain 1983 SCC 435, and on what basis the court can give permission. In Shivnandan Paswan's case 1987 3 SCC page 288, and recently the entire law is summarized by the Honorable Supreme Court in State of Kerala versus K. Ajit. I think all these principles are there. I don't think there is much, and I think what you have collated also, I think it may only require to be discussed or debated as to how this power is misused to serve the purpose of the ruling establishment. I think that is one has to be debated. Otherwise, regarding the powers conferred under the provisions and the manner in which this power has to be exercised are well laid down. There is absolutely no ambiguity. Therefore, I do not think that we need to delve into it. I think I have just covered some of the aspects which I felt, though they may differ from the view taken in the report, which require to be debated. So with that, I close, and I thank the organizers for giving me this opportunity to share my few thoughts with you. Thank you.
Thank you so much, Justice Cunha, for that enriching speech. I think it was rich with anecdotes, and it definitely increased our own understanding of the research that we have put together. As you clearly brought out, there are two sides to this conversation, and we hope that the report put together by the authors will serve as a conversation starter. The report does have a few recommendations, but those recommendations are not white and black, as we have clearly seen. It needs to be debated with the stakeholders within the system before we start with identifying what needs to change in the letter of the law, as well as what needs to change in the way it is getting implemented on ground. Once again, thank you for that extremely engaging speech, filled with legal knowledge as well. So I was taking down my notes. I'm sure the other listeners were as well. I will go back and refer to the judgments that you cited. Thank you. And with that, now we will move to the next segment, which is panel discussion. Before we begin, I would like to tell our audience that you can pose questions in the chat box. We will have around 10 minutes at the end of the session to take them. If you want this to be referred to any particular panelist, you can mention that. Otherwise, it will be fielded by the person who is interested in taking it up. The presentation and Justice Cunha's keynote address touched upon various aspects. And one key element that is clearly sticking out is regarding the contours of the role of public prosecutor herself. While the letter of the law certainly clarifies that there needs to be a demarcation between investigation and prosecution. I will come to you first, Professor Thomas, as to what your opinion is regarding whether this needs to change. And this is not just restricted to the role of prosecutor per se, but also the role of police. We know that police reforms is something that needs to happen quite urgently in our country. And one of the issues that is often highlighted over there is how we need to delineate law and order responsibility of the police from their investigation responsibilities. So taking these two issues between the stakeholder, which is the police, and the second stakeholder, which is the public prosecution, how do you view the framework that currently exists, and how do you propose it needs to change?
Am I audible?
Yes.
Thank you, Deepika. So one aspect is about my opinion regarding segregating law and order. Second is about the general framework and how it is. Okay. If we try to see, in various states, there is segregation relating to law and order and investigation duties. But the problem is mainly, according to me, about post-segregation. What are the issues? Still, according to me, from my research, because last year I was doing an elaborate research for 6 months, associating with various police stations and everything. And I realized, and my research, I think, completely was in Kerala. So I don't know about any other states about, my field visit and everything. The problems are inefficiency, lack of training, crime scene preservations. When I'm saying crime scene preservations, even there are critical issues which are associated with the collection of forensic evidence at the crime scene, quality, importance, preservation. And at the same time, we know that there is a scientific race and the legal race, and we are struggling to catch up. So the problem is that even after post-segregating law and order and investigation, those officers who are there, they need training. That is why I was, listening to Justice Cunha. He made an observation relating to taking advice from the investigating officer. That is, sorry, not investigating officer taking advice from the public prosecutor. So I think why we are opening that arena, one is about whether our system is mature enough for that one. If our system is not mature enough and we are transplanting something like that to the Indian scenario, it is problematic. So silence is extremely important, according to me. And if we are suggesting that as a medicine, that medicine will be worse than the disease. So I think, but when I'm going through the report is making a beautiful suggestion. That is about creating some department for consulting other than the PP. To an extent, we can think about that. But, the why aspect of that question is extremely important. Why I'm saying that the why aspect is extremely important. Why we can strengthen the investigating officer and the agency if we are strengthening the agency and the officer by giving proper training. And I was interacting with multiple stakeholders, especially the advocates and everything. They are saying that it's very easy to destroy this investigating officer because he's not having sufficient training even in collection of evidence and everything. But if we are associating that nexus is extremely problematic. So we should be very careful with that. So investigating agencies' vulnerability or incapability, according to me, is leading to this suggestion. So we should rectify the errors or the issues which are there in the investigating agency, and we can strengthen them. So I think, Deepika, that is what, the first part of your question. But the latter part is about the public prosecutorial system. There, the issues, I'm taking clue from what Justice Cunha beautifully explained. He explained about eligibility. See, I think if we try to see this report, for me, this report, I'm analyzing in the backdrop of, we have a comprehensive report on criminal justice reforms 2003 by Malimuth, that we used to say Malimuth Committee report, where Madhav Menon sir was there. So I had elaborate discussion with Professor Madhav Menon on that aspect. Try to see that they're not ready to touch on this aspect. They are mentioning about the public prosecutorial system, but they are not ready to touch the politicization, the real issues and challenges. After that, 2007, again, report of the Committee on Draft National Policy on Criminal Justice Reform, that is by N.R. Madhav Menon. There, just try to see it's, I think, somewhere around in public domain, it is of near about 100 pages. But there also, they are saying there are some problems, but they are not ready to identify. See, Law Commission 14th, or 197th, or in between there is one more report. 197th report, our Law Commission report are infamous for its numbers. But when it comes to public prosecutor, they restricted it to 36 pages. So what I am trying to say, from eligibility, my problem is not with eligibility. My problem, whether the people who are getting appointed as public prosecutors, whether they are fit to this, because we have, multiple sections, or you can say that, the provisions which are, we are making sure he's an independent person, he is, qualified, he can do, impartially the job and everything. Because if you try to see, I think my issue is that if you try to see the architecture of criminal justice system, one is about the institutions or buildings which we are, criminal justice system is carried out. You can say courtrooms, police, jail, whatever be the thing, that is in a narrow aspect. But if you try to approach it from a broader perspective, that includes values and principles we are trying to protect. Dignity, one, fairness, objectivity, neutrality, impartiality, and everything. If you try to see the public prosecutorial system, these elaborate provisions are for that, because we need these officers to be independent, impartial, and everything. Because these are the values. That is why we are saying that tethering of constitutional law principles with criminal law. Or we can say constitution, because we the role, what is that public, how to interpret the word public? I don't know how they are interpreting the word public in public prosecutor. So do we have any mechanism for checking the track record of these people who are getting appointed? Whether there is any scrutiny relating to the manner in which they are conducting the case? Is there any department which the state or the High Court is creating to scrutinize their judgment, to understand how the manner, the way, the whole aspect of conducting the case? Every year, what is the problem with coming up with the report, scrutinizing their work and everything? What is the problem with that? Another crucial issue we are not discussing, I think, our report, I think, preferably mentioning about delegation of cases. I thought that got over, because last year only I did research on that aspect. Public prosecutors are delegating their work to their juniors. We have elaborate provisions for ensuring so many things. I'm not again and again saying, but by taking one word, acting under those people without any criteria, any parameter, just giving it to the juniors, how we are doing justice? Because we have a tendency, wherever blatant justice violation is there, we use the word justice. One such place is here, but other place is our sentencing justice and everything. So my issue is that these are the main problems which we should rectify. And if we are not seriously taking this into account, there is a chance, especially relating to the whole public prosecutorial system, it will collapse. And please try to see, Justice Cunha mentioned about that issue relating to Jayalalitha. I used those judgments and everything, even Bhavani Kumar Pandey's appointment and everything. I think he can explain it, because of paucity of time, he didn't enter into the detailed analysis of that. Just read that, to what extent the Indian state of this public prosecutorial system, you can understand. That is starting with our Sunil Kumar Paul versus Potashe onwards, you can see that every year we will be having multiple issues which are clearly showing that the system is about to collapse, or you can say that there is no discipline in this. Thank you, Deepika. If you need any other thing from my side.
Sure. Thank you for that, Professor Thomas. Very insightful, and you touched upon a range of issues over there. But the last issue is what I will pick to go to Advocate Bansal, because that beautifully leads to what I was going to ask him originally, which is that we are talking about it as on the one hand, researchers, the issues with respect to the Office of Public Prosecution. What the report does is mostly based on research that is already out there, data that we have been able to scrape as outsiders to the system, so to say. And Justice Cunha and Professor Thomas play other diverse roles within the justice delivery system. But you are right now in the thick of things. You are experiencing the kind of office that is currently in place with the kind of framework that the CRPC currently provides. So if you can, basis your experience, throw light on some of the issues that are being debated over here, especially looking at what the challenges are for a public prosecutor. We are looking at what challenges the system faces, or what challenges the accused or the victim is perhaps going to face because of a seemingly broken system. But equally, we should also be looking at what the public prosecutor as an official is undergoing day in, day out in that role. So both these sides, if you can deliberate upon for us, it will be useful. We can't hear you,
You're muted.
Mr. Bansal. Can't hear you yet. Kana, can you see in the background if you can unmute Mr. Bansal?
I'm just trying.
Can you speak now, sir? No, not yet. Not yet. While we wait for that to be fixed, Advocate Bansal, if you can turn off your video and try to speak. No, still not audible. So perhaps you can log in again or reconnect your audio system. All right, we will come back to you. But in the meanwhile, I wanted to go to Justice Cunha. So we have spoken about how it is, how the Office of Public Prosecution right now seems to be functioning under executive pressure. As in, sometimes it is high when there are politically charged cases or when there are elections taking place, but oftentimes it goes unnoticed. As a judge, within the framework that we currently have, what are the various measures that can be taken to perhaps discipline errant public prosecutors? One of the challenges is also that most often things are not within their control either. How does a judge balance between what is right for the case with the very obvious pressures that the officer of the court is working under? Do you have any tricks that you can share with us, basis your experience? So can you please unmute?
The fate of a case, fate of a criminal trial is not dependent on the investigation or the assistance given by the public prosecutor. I think courts have got ample power to get into the truth. If you see section 165 of the Evidence Act, you just see the power of the court. So even if the investigating officer plays truant or plays mischief, at the time of taking cognizance itself, we have got a power. We can send the matter for further investigation. At the stage of 319, if any evidence surfaces, we can proceed against any of the accused which has been left out by the accused. So therefore, court is not helpless. And more than that, if public prosecutor also does not assist, court is not helpless. You just see section 165 of the Evidence Act, how wide power has been given to the judges. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases, in any form, at any time, of any witness or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing. So no rules which are all the preceding rules are there, which give some right, are binding against the court. Section 311, he can recall if he wants, in the interest of the justice, to arrive at a fair decision, he shall. So that means that power is given. So therefore, all these, and if any judge who really understands it, I don't think that is he can give up his answer. This one give up saying that there is no sufficient assistance, and that, of course, if the evidence itself is not before the court, I think there may be some practical difficulties. See, collection of the evidence, that is what one of the area what I said. See, if public prosecutor and the investigating officer join together, and if the evidence itself is not brought up, or the evidence itself is manipulated, to see that the charge brought by them has to stand or not to stand also. Because both purposes will be there. That is what we see now in a reality. See, in a reality, and that is the main drawback in our criminal justice system. But the court takes care of all these situations. That is why that investigating role means what? Investigation, what he does? He collects the evidence. See, these are the traces of the offenses. They should come before the court as it is, without any manipulation. You don't want a legal mind to substitute that. You should know what evidence should be collected, what is available there. That is presented. That is why that is in the public prosecutor. He should not thirst for conviction. That is not that. He places the facts before the court. If these facts make out the ingredient of an offense, court frames the charge, and public prosecutor's duty is to show to the court. So look, this evidence makes out the offense. This evidence does not make out an offense. So therefore, the system is full fruit if it is properly implemented by people who know their respective role, even be it investigating officer. Now you say that, talk about this inefficiency about the, in Lokayukta cases, how efficient investigation has been done under the PC Act, the very same investigating officer. Why they do it? And if you do not have any legal advice, if you want any legal advice, you appoint your own man. Why you get the public prosecutor there? If you want to strengthen your investigating department, you have to. You should have a qualified, trained investigating officer. If not, you take in the department itself. Public prosecutor's service is not meant for that. He's an officer of the court. Tomorrow he has to stand. He's just like, if I have to explain to you, his role is just like in the seesaw, that is a supporting central support. And one side there is the investigation, and this side is the judge. He is the middleman that supports the case. His role is that if by the weight of the evidence the investigation goes down, that is the fallout of the investigation. He cannot be asked to improve that, because if you ask them first itself at the investigation stage to help him, he will see that side is heavily stacked. So that cannot be the rule. So there is the procedural code as it is. I think takes care of all the situations. Yes.
Right. That is a beautiful analogy, Justice Cunha, that of a seesaw between the investigation agency and that of the court. And I think with that, I can come back to Advocate Bansal. Right. It was echoing. I hope I'm audible.
Yes.
Am I audible, ma'am?
Yes, yes. Advocate Bansal, I will pose the question again with a slight nuance, given that we have just heard Justice Cunha speak about what the actual role of a public prosecutor is. He is, at the end of the day, the officer of a court. That is perhaps the definition of public, as we will have to see it going back to the point that Professor Thomas was making. And in that, given that you have to balance between the expectations of the court the expectations that it has of you with that of what the responsibility is towards the investigation agency. Can you tell us, basis your experience, what the challenges are in juggling between these two institutions while keeping yourself true to the principles that Professor Thomas highlighted, which is that you have to be independent, you have to be impartial, etc. Over to you, Advocate Bansal.
Thank you, Deepika. Now, there are two aspects. One, the judgments, and the second one is the practical, what we always see in the court. As far as the theoretical knowledge, the judgments and book says, a prosecutor should be impartial in the court. I am the officer of the court in the court. But what is the practicality? In practical, I am not independent because I have the responsibility. Being a government servant, I cannot stand in the court and say, Honorable Court, please grant the bail to the accused. There is no evidence against him. I cannot say that. If the court will record the statement that yes, the prosecutor is saying this, please grant the bail, I have no objection, then that will go against me. I am a state government. Anybody can raise an objection on it. The complainant can raise the objection. He can file a complaint against me and my department will take the action against me. So I cannot say this. My duty is to be impartial. I have to assess the court whether accused has committed the crime, whether complainant is saying right in the court or not. But practically, I always help the complainant. I speak for the complainant and the court, rather than speaking for the accused that yes, he has not done anything. Now, the few issues which has been raised by Justice Cunha and Mr. Thomas, like the appointments of the prosecutor. I don't think these days there is much problem in the appointment of the prosecutors because of some regular cadres. Let me give the example of few states like Delhi, Himachal, Punjab, Haryana, MP, UP. In all these states, they are appointing prosecutors through a process, through a good process. Like in Delhi, UPSC conducts exam, then they conduct the interview. So this is the process to appoint an assistant public prosecutor in Delhi. But as far as the special public prosecutors are concerned, or the prosecutors in Honorable High Court, yes, there is political interference in it, as well as there is interference of the government. As the Department of Prosecution works under the Home Department of the state. So yes, there is interference at the time of appointment of special public prosecutors and the prosecutors in the High Court. Otherwise, there is no problem in the appointment of the prosecutor. But what other problem a prosecutor faces in the court? That is the lack of training. When a new prosecutor joins the department, at that time, there is no system that he'll go for a training like a magistrate. After the appointment of a magistrate, he gets a training of 1 year, 1 complete year. But a prosecutor gets basically not a training. They will attend.
Mr. Bansal, your network seems to be patchy. Can you turn off your video, please? I think that will be better. Are you there? I think we have lost him. Mr. Bansal, are you there? I guess not. I think we have lost him. We'll wait for him to rejoin. And in the meanwhile, one point, a very interesting one, and I must commend Mr. Bansal for being so fair and frank about it, was the dichotomy between what is there on paper and what actually happens in reality. Mr. Bansal,
Yes, am I audible?
you are. You may continue with your point.
Yes. So I was talking about the training. That is the most crucial part, that one should get the training. So as far as the allotment of cases or promotions and all other things are concerned, and these days in like lower courts and subordinate courts, there is no such problem in those things, because being a prosecutor, I'll get a particular court. I am having a particular jurisdiction. I'll see all the cases with regard to that jurisdiction. This is the practical problem which usually one face in the court. And if you want to ask, like we were earlier,
Mr. Bansal, do you want to switch off your video? I think that will be better. We have again lost you. Okay, I think we will move on and see if he can rejoin. But now 2 points that stick out for me when from what Mr. Bansal spoke. One was how it is quite impossible for him to be impartial. Him and almost everyone else in his position, I'm sure, to be impartial, given that the executive interference is going to be there, one, and two, also because it is going to backfire if he actually presents an honest opinion with respect to the fitness of a case to proceed forward to the trial stage, or even once the trial commences, if he says that, you know, bail can be granted. To that, what is your response, Justice Cunha? Have you seen this play out in the court where a public prosecutor has been frank with his or her opinion? What were the repercussions? What is your advice for anyone who is in that position?
I think Mr. Bansal was very candid. I think that is exactly what we were hinting at. See, it is one thing to say he is an independent officer, but as long as he is under the control of the executive, I think he cannot survive at all. If I don't think there is any public prosecutor who dares to go against the instructions that he receives, or the directions, I would say, of the executive. So he was very, very candid or very fair in that, and that exactly is that. You now take a simple example. See how this case, let us say, if a murder takes place, and that happens to be one of the party worker. Now, in all other cases, the charge would be under 302. But if it is a party worker of the ruling party, they want to bring NIA. Then the evidence may not suggest, but all efforts will be made to bolster up that charge. And public prosecutor will see that at least if he's what you call, as far as possible, to substantiate that charge. So therefore, that is how it is, because they play as per the, they dance as per the directions of the executive only, and they have to. They have to. I have not seen any public prosecutor who was otherwise under while withdrawing the this one, what you call, under 321, when withdrawing the prosecution, what the law has said, even the judges have laid down that you have to take a call. You have to show that you are independent. But how many people do it? Hardly anybody. So they cannot. That is why I said this: the public prosecutor cannot join hands with them. It is okay with the investigating officer. He can be under their home department. And another point what I made is that I think we have been arguing about the public prosecutor assisting the investigation. I think what Mr. Bansal said is that we ourselves are not trained. If we ourselves are not trained, your position is just that of an advocate. It is one lame person cannot lead another lame person. If the investigating officers themselves are untrained in investigation, this person who is untrained also cannot instruct them or cannot give them advice. So all these things are there. It is, as I said, that this one, what you call the training. I think that must be made one of the compulsory this one, and that is the way. I think not only the proper assistance could be given by them to the court. Otherwise, just like any the background in which they are selected, even the person that I said, because if it is the only consideration is the party affiliation, I think his capacity is what you call caliber is not considered at all. So therefore, if at least to offset that, you give him training, even if you can, because as we said, the Supreme Court has said that it is your prerogative to appoint. Okay, you appoint, but give them a thorough training so that they could give assistance. And their primary role is to give assistance to the court.
Right.
Yes.
Right, absolutely. Thank you for touching upon both those points, because I was going to come back to you on the training bit as well. Back to you, Mr. Bansal. I hope we can hear you out completely this time. But in case there is any issue, I would suggest you switch off your video and continue speaking. I think that might help.
Yes, ma'am. So, as Justice Cunha was just saying, there are a number of prosecutors. I think all the prosecutors, 99% prosecutors are daring enough these days who stand in the court and speaks the truth.
Yes.
I can give you one example. Recently, I do not want to disclose the name of anyone. A prosecutor had moved an application against one IAS officer. He was chief secretary when he had moved an application under section 319. He was a really smart prosecutor. The accused should be the chief secretary of the government, and he had moved an application. A lot of pressure was there on him, but he didn't turn back. He moved an application. Later on, the chief prosecutor, what he had done, he, with the help of somebody, the prosecutor was transferred from that court. The matter was transferred from one court to the other court. But what the prosecutor had done, he had moved an application. Now it's on the judiciary to decide that application. So as far as that prosecutors are not independent, this is completely wrong. Prosecutors are independent. They work independently. As far as we were talking about the training, as far as my little knowledge is concerned, because if you want to be a prosecutor, you want to appear an examination to be a prosecutor, then you have to have an experience of 3 years. So maybe this is the reason behind it, that department thinks that the person who is already a practicing lawyer, he has practiced in criminal law or in civil law, he knows about the law from last 3 years. Maybe department thinks that he doesn't need much training for this. As my father was a lawyer, I practiced for approximately 6 years prior to coming to this department. So like people like me don't need any training to be a prosecutor. So the independence with the prosecutor is there. Yes, the training part is a little bit lacking point. And as far as the nexus between the investigating agency and the prosecutor is concerned, what I feel is investigating agency should consult the prosecutor during the investigation if they want to collect the better evidence, because there is no law or there is no notification or order of any of the authority. Because of this, all the police officers do not approach the prosecutor during the investigation. Yes, the one part is there after completing the investigation and making the draft charge sheet. What investigating officer is bound to do, he has to send the charge sheet to the prosecution department, and the concerned prosecutor will review that charge sheet or scrutinize that charge sheet and find out the lacuna in that charge sheet, will write it down and send it back to the IO or to the SHO so that they can comply with all the objection which has been raised by the prosecution branch. This is the one step which has been taken to make the nexus between the investigating agency and the police officers. But what I personally feel is there should be some nexus so that, like countries in US, they save so much of time to stop the frivolous cases to go into the court, because the prosecutor has the power to see that file, to see the investigation, and prosecutor has the power to sign and forward that case before the magistrate for trial. But here we do not have such power that we can forward that charge sheet to the court. But there are few states in India, as I know, only 2 states, Punjab and Haryana, in which the police official will prepare the charge sheet, he will send it for scrutiny. The charge sheet will again go back to the investigating agency. They will fulfill all the points and send back that charge sheet along with that compliance to the prosecution branch. Then the concerned prosecutor will forward that file to the magistrate for trial. This is a very good practice. In a recently, I do not remember the name of the judgment, the Honorable Delhi High Court also written the same in one judgment, that the investigating agency should go to the prosecutors or go to the prosecution branch, and the prosecution branch will forward that charge sheet to the court for trial if the case is fit for trial. But nothing had happened in it.
Right.
So this is the practical
Right.
situation right now.
No, thank you for
That
that.
is
And that sort of yes, Justice Cunha.
Deepika,
Yes,
if I have
yes.
to, I think what Mr. Bansal said, there is no principle or the proposition of law. I think I referred to R. Sarala versus T.S. Velu, where in para 12, so thus the public prosecutor is to deal with a different field in the administration of justice and is not involved in investigation. It is not in the scheme of the code for supporting or sponsoring any combined operation between the investigating officer and the public prosecutor for filing the report in the court. That is a direct decision of the Honorable Supreme Court, which says that, and thereafter, even in Karnataka, we had that practice. It has to be vetted by the public prosecutor. That was discontinued after this decision. And even this decision goes even a step further. It says even the investigating officer should not take instructions from his superior officers. See, that is to maintain the purity of the administration of justice. A person is that he is accountable, he is answerable to the court. Otherwise, if every person goes and takes instructions from this one, there is a purpose behind that. So here in para 15, in this context, we may also find out that the investigating officer, though he is subject to supervision by superior in rank, is not to take instruction regarding investigation of any particular case, even from the executive government of which is subordinate officer. So that is the Supreme Court goes even to that extent. Unless this is overruled and what is Mr. Bansal can make some study. It is, but anyhow, it is a debate. As you said, I think they have collated this information in the report also about the Delhi High Court, Punjab High Court holding a different view, Madras High Court holding a different view. But it is maybe a debatable issue. It is.
Absolutely.
Yes.
I think that is the key takeaway from this discussion, that the role of the public prosecutor as it currently is and what it should ideally be is something that is open for debate. And I think Professor Thomas had a point on this. Do you want to quickly take that, Professor Thomas, because we are running short of time and I would like to take audience questions as well.
I just need only 3 minutes, Deepika. First is about when we are discussing about issues and challenges, mainly relating to appointment and everything. We are not discussing about assistant public prosecutors because theirs is a permanent appointment.
Yes.
See, the problem is coming with PP. Yes. There is no examination. Just try to see that, because recently I conducted a study in which majority of the bar is saying that the people who got appointed in the sessions court, 70% people are incapable because they are saying that they don't have any track record. Not about assistant, because actually when examination is coming, then there is like a standard criteria, parameters are coming, we are happy. That is why, especially when it comes to APP, because there's a 10-year appointment, they will be retiring, they will be getting, and I don't know what of you. So this eligibility, appointment, scrutiny, there also we need scrutiny and everything. But mainly the problem is coming with PP, one, especially who are there with the sessions court and everything. Second, see, even I also practice for time. The problem when it is coming, when we are saying about to consult with the investigating officer, the value which we are trying to infiltrate is at any cost we need conviction. Why? I think the problem is coming. I think you want to construct the case in such a manner in which there will be no loopholes. It should be perfect and everything. That is what, if you try to see the silence of Sarala, I think the judgment of Sarala versus Velu, the silence of that judgment, after that also we have Cantina of decision. But we used to cite Sarala because Sarala is jurisprudentially, it's a nice one. So the silence of Sarala itself is that why we need that, nexus. In the sense, then it will be like you are writing a script. You will be getting, then you will be, trying to cut the loopholes and everything. Actually, if we try to see how we are, mapping the role of a public prosecutor, he is not even, that is why when it comes to withdrawal of prosecution, the whole jurisprudence is that state will be appointing. After that, the control of the state is withering away and he is the sole person who is taking decision. Only the court, even when we are discussing about the relationship between the PP and the court, we are saying that, okay, court will only monitor, not to the content and everything, only just to oversee that whether the decision is correct or not. So my whole issue is that the why aspect is a bit problematic. I just want to say, but when it comes to assistant public prosecutor, we don't have much issues. I think to an extent, when it's a permanent appointment, when I think to an extent, especially when it comes to Delhi's like, states like NCT and everywhere, it is, fine. Thank you.
Thank you, Professor Thomas. Yeah, that demarcation between the way in which I think different kinds of public prosecutors are appointed, the ones functioning at district court level and the others functioning at high court level, is critical, because systematization has happened only for the former part, which is appointment of public prosecutors in the subordinate judiciary, but high court continues to be in the control of the executive and most often politically motivated. And that actually leads to one of the questions posed by an audience, Mr. Nina Dua. If I may read the question out, and I leave it to the panelists, whoever wants to take it up. A question for consideration: with major political parties comprising legal luminaries themselves, should it be made mandatory for the eligibility as public prosecutor a sworn affidavit denying any alignment or subscription to any political party, and liability of disbarment if proved otherwise? Justice Cunha, do you want to take that up?
You mean to say that while appointing, they have to swear to an affidavit that will be, even otherwise, the law requires to be independent only. Even filing and swearing an affidavit makes no this one. I think that is what Mr. Bansal said. That is, see, I did not, of course, Mr. Bansal, it is my intention is not to generalize it, because I had the benefit of, at least if I had learned some of the aspects of the criminal law, it is from one of the prosecutor only. So that there are good prosecutors. I don't intend to generalize, and I have in the open forum I have admitted it, especially from the Lokayukta court. We had such a wonderful this one and such upright, and he resigned because he could not take the pressure of the work. So such officers are there. Such officers are there, and you also may be one of them, and that is what is expected. But the system does not permit us to do. So in that situation, even if a sworn affidavit is filed, I think that affidavit, it must be mandated under some statute or some law. Then only it has got some this one bearing. Otherwise, that itself may not make much difference unless you put the rules in place. Rules in place. As APPs, there is a system is in place. Transparency is there. So therefore, there is such a system you put it. Otherwise, at least to improve upon that consultation, at least there you just make a kind of selection at least if not this one recruitment, at least a selection process.
Right.
Yes, I see that is how this is purpose could be. It is not that it cannot be. It is you want to retain complete absolute control of your own man who is pliable. Only such person should not enter. That will defeat the very purpose. So therefore, this swearing an affidavit, according to me, at this juncture, in the absence of any rules or regulation, may not make much headway.
Absolutely. I think there is more concrete measures that are necessary than just a tick box exercise, which this affidavit will end up being.
Yes.
We need something more structured at the High Court level as well to appoint public prosecutors. And there needs to be a thorough rethinking on how special public prosecutors are selected and appointed and on what cases. There are a couple more questions, but I think over the course of this discussion, they did get answered. So I will leave them out. And what I would request all the panelists to do is take a couple of minutes to give any final remarks if they have, or touch upon any point that they thought was important. And I'll start with the authors now that they have heard this discussion, if they have any key takeaways with respect to the findings of this specific report or any fresh ideas for future work. Chitrakshi, you want to go?
Sure. I'll of course defend my opinion in the report that there should be a greater role for the prosecutor at the pre-trial stage. And I will back it by two statements. The fact that the charge sheeting rate of the police is very high. In the latest NCRB report, it's close to 76%. If you look at the conviction rates of courts, I think the average should be around 40, and there will be a huge variance across specific crimes. The fact the code is structured in a way that it should funnel out cases from entering the criminal justice system. And I'm not saying that the evidence should be enough to secure a conviction, but to at least pursue a trial. Secondly, the other point that I wanted to make was the executive interference is, of course, visible in appointments. But for example, we saw in Maharashtra where the state government tried to make rules imposing certain conditions on promotion of prosecutors by saying you need to secure a certain percentage of convictions. And it was later struck down by the Bombay High Court. But in the Madhya Pradesh government, this practice is still continued as not a rule technically, but they have an incentive scheme for prosecutors where if they secure certain percentage of convictions, they will be, they are incentivized to do that for their career progression. So these are also other soft, subtle ways of sort of diluting and reinterpreting the aims of the criminal justice system, where obviously conviction is not the aim or end of the criminal justice system. So it's also the perspective you bring to the study of prosecutors that should be evaluated. That's all. Thank you.
Thank you, Chitrakshi. Aditya?
Yeah, certainly seconding Chitrakshi's point there, and I was going to bring up this point of executive interference as well, where securing, where the thirst of conviction that we have talked during the course of discussion, that is being played out in a sense that certain prosecutors are being tagged as star prosecutors because they have secured certain convictions. So these are the ways in which we think that, yeah, executive interference is being played out currently, and there has to be a check to that, addition to withdrawal of cases and appointment of SPPs and appointment of prosecutors in higher court. That's what we intended to take this conversation forward and title the report as a quest for prosecutorial independence. And I think that this discussion was really fruitful, taking the opinions from different perspectives, and then a really fruitful discussion to take this report forward and also to guide us forward in this research.
Thank you, Aditya. And on the point of star public prosecutor, I'll go to Mr. Bansal to see what final comments you have.
Basically, what do you want to ask direct?
Any final comments? Any final comments before we close the session?
The final comments is this, ma'am, that a prosecution department is an independent department. And yes, there is a little nexus between the investigating agency and the prosecution. And that nexus is a little bit good for the part of investigation also, for the part of justice also. As far as you have written in the report that this much cases have been charge sheeted in this year, and how many were there, out of them, how many were the closure reports? Yes, they file the closure reports also, they file the untraced reports also. But if there is some evidence, if there is some prima facie evidence against the accused, it is the duty of the investigating agency to file the charge sheet in that case And being a prosecutor, it is the duty of the prosecutor to bring the justice at home, to go for to help the victim, to help the aggrieved party. And this is what I want to say.
Thank you, Mr. Bansal. Professor Thomas, if I may come to you for your last comments.
Deepika, I don't have, whatever I want to convey, I already conveyed.
Thank you. Justice Cunha, any last comments from you?
No, I think I already talked enough, I think, no?
All right. Thank you so
Yes.
much. That is also a cue for us to close on time. We have overshot by a few minutes, but I think this was a very engaging discussion and it will work as a fodder for our future work, I'm sure. Thank you once again, all the panelists, Justice Khanna, Professor Thomas and Mr. Bansal, and our authors for joining us, and all the participants who have stayed with us this late. Thank you. Have a good evening.
Thank you, everybody. Thank you for your time.
Thank you.